It is all the news all the time, and it's really nice of you to be here. And if you are here, hit the old like button and subscribe if you haven't already. And we're looking at some interesting news today. I'm going to have to give you a speculation warning on this because I can't verify some of the facts. But very interesting indeed. Asking the question, is Johnny Depp another victim of the corrupt UK justice system? This is coming out from Intelligence UK. And a very interesting story. They were saying in our last article in May 2021, we reported on how Johnny Depp came to the UK to seek justice and was deprived of the right to a fair trial. And this seems to be a story which is all too familiar, with many thousands who come to the courts in the UK to get justice, only to be served with more injustice. We're saying that the US courts are more focused on delivering justice. So earlier this week, on the 17th of August, the Chief Judge in Fairfax, Virginia, presiding over the Depp v. Heard case, dismissed Heard's claim of res judica, which is stating all matters have been tried in the UK, and endorsing our view and citing in the 11-page pre-trial opinion, the court is not persuaded by the defendant's argument that the plaintiff had a fair and full opportunity to litigate the UK action. The defendant was not a part of the UK action and was not treated as one. I think this is a key point here because Amber Heard, obviously is the defendant, wasn't part of the UK action. The action in the UK was Johnny Depp versus the Sun newspaper, not Johnny Depp versus Amber. In fact, as it continues, the defendant, Amber Heard, could not have been named as a defendant in the UK litigation because her allegedly defamatory statements were made after the UK action started, said the judge. So clearly she can't be called in as defendant. So this leaves a major problem. After our intensive investigation, says this organisation, it is our view that the allegations by Heard and the assistance by the UK's corrupt judiciary is nothing other than an elaborate fraud designed to discredit Johnny Depp, whilst using the high-profile allegations to drive traffic to the Sun newspaper. Wow, bold statement indeed. We've got some table of contents here. Well, firstly, we're looking at a conflict of interest in the issue. They're saying the UK trial was a sham. The judge, Andrew Niccol, is intimately connected with Dan Wootton, and Dan Wootton is the Sun journalist who posted the defamatory allegation that JD was a wife beater. So how is the judge intimately connected with this guy? The connection is through the judge's own son, Robert N. Palmer, who works alongside Wootton, the journalist, at Talk Radio, part of the same group owned by Rupert Murdoch's news group. Right, so Wootton is a journalist and broadcaster from New Zealand, and he's an executive editor of the Sun newspaper and a regular host of Talk Radio's Drive Time. So he comes in and gives talks, gives a show on Talk Radio. Wow. So this is clearly an incestuous conflict of interest, putting it mildly. And why, knowing of this conflict, did Mr. Justice Niccol preside over the case? Why, in such a high-profile case, did the Lord Chief Justice allow Mr. Justice Niccol to preside over the case when any other judge could have done so? We believe the answers are naturally self-revealing. Other elements of the case which were troublesome are Johnny Depp's counter-allegations and evidence were ignored. We went much further into the court papers. It's our view that all Niccol Justice was interested in is Heard's evidence and submissions that would solidify the Sun's defamatory allegations. The central allegation by Heard was that on the evening of 21st of May, JD violently attacked her and enraged through a mobile phone at her face with extreme force. The resulting evidence of injury resulted from the mobile phone at Heard's face was nothing other than what would resemble a mere zit, and upon analysis of the various versions of the photographs of the alleged bruising, we conclude that many of the photos posted by the mainstream media are entirely inconsistent. This is borne out by the Virginia trial, in which the photographic evidence was rejected by the jury, and they claimed, or they stated, that they hadn't put no faith in it whatsoever. Here we have one of the photos. This is taken within 3 hours of the alleged incidents. It shows a slight blemish to the upper left cheekbone. No visible sign of blunt force trauma. Close up we have reddening, but no swelling or damage. Close up here we have zits and nothing to be displayed. Again, analysis of the mobile phone attack allegation in 2016 mobile phone, taking into account the latest brands, which were out in May of 2016. They weigh between 140 and 200 grams. If thrown with excessive force, as claimed by Heard, even if the flat side of the phone made first contact, there would be instant and significant bruising. Whereas if the corner of the phone made contact with the upper left cheekbone or at the base of the eye, we would expect to see rapid and substantial swelling and blood redness from a periorbital hematoma. Photographs are entirely inconsistent. This has been throughout all the cases. The claims of what happened and the photographs of the evidence don't match. They've never matched, and this is what's affected her credibility. Police officers at the time, at the scene, both domestic violence trained, saw no evidence of injury or damage to the property, again wholly inconsistent with Heard's evidence and testimony by her witnesses. Officer Sands, after conducting a sweep of the scene and meeting with Heard, testified, "I did not identify her as a victim of domestic violence." Further fabricated allegations, bruising which magically disappears the same day, and this is different lighting. I was looking here, this darkening here around the mouth magically disappears the same day in a photo a few seconds later. We have the towel rail, the bathroom, ceiling. Depends on the lighting. So is this bruising? But then it's magically gone. Is this bruising? It's magically gone. Red mark of the right eye, some change shape and colour. It is, in their opinion, in our view, that these photographs are a mock-up. Complete fabrication, they're claiming. Wow. The denial of the right to adduce fresh evidence on appeal. JD was denied the right to adduce, which means bring in fresh evidence in support of the fact that AH's evidence and testimony is false. Pursuant to the Civil Procedure Rules 52.21.2, the Court of Appeal will not generally consider oral evidence or evidence which was not before the lower court. So in the case of Hamid and Francis Bradshaw Partnership, Lord Justice Jackson held that the default position under the Civil Procedure Rules is that fresh evidence is excluded. However, that does not undermine the quality of the fresh evidence, namely the attending officer's body cam footage, which once again provides a completely different scenario. So, a summary of the proceedings. A key part of the High Court trial was the testimony from Heard that a $7 million divorce settlement had been donated to charity, with the money divided between the Children's Hospital of Los Angeles and the American Civil Liberties Union. Heard claimed that the entire amount of my divorce settlement was to charity. It was found, however, that Heard gave just £72,000 to the hospital and $322,000 to the ACLU. How interesting. Claiming that a further $358,000 donation was made anonymously. Wonder who by. The finding was substantially different, once again, to Heard's claim that the entire amount was donated, and yet Mr. Justice Nicol was not prepared to further drill down into the matter. So it was meant to be $7 million, and it turned out to be 322 plus 72 was actually donated, with a possible 358 made anonymously but difficult to prove. So this amount was that 390,000 instead of 7 million. Yeah, big difference between numbers. So Justice Nicol not prepared to further drill down into the matter. Acting for the newspaper conglomerate, Adam Wolanski, Queen's Counsel, said that whether or not Ms. Heard actually did pledge these sums was not a pleaded issue, and the judge was therefore not required to decide on it. We disagree, as demonstrated that the statement made by AH was false, would have undermined her credibility as a witness, as it was in Virginia, and should have therefore given the fact-finding tribunal cause to further investigate what we have herein demonstrated to be a very dubious evidence and testimony. Mr. Justice Nicol concluded 12 of the 14 alleged incidents of DV relied on by the newspaper did occur, yet the evidence and conflicting statements suggest otherwise. The proceedings are mired in the usual spin of trickery and deceit that our group has seen so many times over in these ways the judges operate, favouring the corrupt corporations and their regular magic circle law firm attendees. There is much more to the case than meets the eye. More will be revealed in our next article. So there you go. Don't forget to like and subscribe. And as you can see here, 81.8% of people watching these videos are not subscribed. So disappointing. So if you do get a chance, do press the old subscribe button. It really does help the algorithms. We also have new memberships now, so you can join members, be a member, get some bonuses there. And yeah, like, subscribe, hit the bell notification, and I will see you guys later.